featured very prominently in the planning of the murder of judges on June 30th, 1981. And this can be read about in the special investigative report on that terrible event in our nation's history. It will be recalled that there was a Major Samakwa, a military officer who was killed with the 3 High Court justices, who was the director of human resource of Gihok. He was my uncle and my guardian when I entered the University of Ghana in September 1980. I was also living with him at the time he was abducted and murdered. Was Edu Lodge chosen for my inquiry to make me feel insecure? I think so. And I continue to hold the view that there's no reason why a judicial hearing is being conducted behind the high walls of Edu Lodge. At this Article 146 hearing, no rules provided by law to regulate the fairness of hearings and trials in this country for removing them from office under Article 146, and these grounds must reach the standard of, quote, inability to perform the functions of their office. The officials include, apart from Superior Court justices, commissioners of Traj, commissioners of NCCE, commissioners of the Auditor General, and the chairman and the vice chairman and members of the Public Service Commission. The third reason for this statement is that in order to address the troubling violations of the Constitution and illegality of the proceedings that have become obvious to me, that became obvious to me from the beginning of the process. I started an action in the Supreme Court. I applied for the proceedings of the committee set up by His Excellency the President to be held in public, so that in the interest of transparency and for the truth in the matters being raised to be made known to the people of Ghana. I did so because I knew that the secrecy of the proceedings for removing justices was not created in the Constitution as a cover-up for any agenda. The Constitution expects that only reasons for removing the Chief Justice and public officials as set out in Article 146 will be the reason for doing so. And especially, such reasons must affect sensitive national interest or public order or safety. I realize that in my case, should the public be made aware of the allegations in the petition, they would realize that none of the allegations made border even remotely on matters of national interest or matters of public order or safety, or anything that indicates that I'm unable to perform the functions of my office. An example is an allegation that I failed to retire accountable interest of $14,000 when I traveled. When I did retire that accountable interest 2 days after I returned from my journey, I was given $14,000. I could only spend $4,400, and I returned $9,600 2 days after I returned from Ghana, from my journey. And so I knew that it was necessary that the issues being thrown around as petitions against me needed to get into the public space. I swore to a supplementary affidavit alerting the Supreme Court also of human rights violations that I had started encountering when I went to the Article 146 hearings. However, the members of the Supreme Court that had the action for the hearing in open, and they also struck out the supplementary affidavit at the request of the Attorney General. I have decided to make this statement today because the violations have not stopped. Indeed, they have escalated beyond anything I could have imagined as possible in justice delivery. These violations include the committee's refusal, in breach of the rules of natural justice, to recognize my lawyer on the first day of proceedings, simply because I was not personally present with him. And they went ahead to make arrangements for the hearing without involving my lawyer while he was sitting in front of them. The committee has also failed to indicate the specific charges that I'm supposed to be defending myself against in order to allow me to adequately prepare a defense to the charges. The committee has gone on to permit two of the petitioners, Mr. Daniel Ofori and Shining Stars, not to testify at all or present what case they brought to them at the hearing. The committee has refused to allow me to go into the hearing with any family member. Before you enter, there's a thorough search of my body and my handbag in violation of protocols and courtesies extended to any Chief Justice, which protocols and courtesies are honored in the name of the nation, both in Ghana and outside of Ghana. And then the work of the committee is being conducted in a cordoned high security zone on Castle Drive, Osu, when all Article 146 proceedings since 1993 have been held in facilities of the judicial service. It is hard not to reach the conclusion that the choice of venue against the backdrop of secrecy of proceedings is intended to intimidate me and to prevent any citizen of Ghana from knowing how the proceedings are being conducted. The Edu Lodge facility that the hearings are being conducted in featured very prominently in the planning of the murder of judges on June 30th, 1981. And this can be read about in the special investigative report on that terrible event in our nation's history. It will be recalled that there was a Major Samakwa, a military officer who was killed with the 3 High Court justices, who was the Director of Human Resource of Gihok. He was my uncle and my guardian when I entered the University of Ghana in September 1980. I was also living with him at the time he was abducted and murdered. Was Edu Lodge chosen for my inquiry to make me feel insecure? I think so. And I continue to hold the view that there's no reason why a judicial hearing is being conducted behind the high walls of Edu Lodge. At this Article 146 hearing, no rules provided by law to regulate the fairness of hearings and trials in this country are being followed.